Yes, hi everyone. During this session, we're going to talk about trust of land, trusts of land, and how they combine freehold land or a leasehold land. I mean, how they combine in the state that they affect. Since let's say that we got the freehold land here. That's the estate, freehold land, and that it has its own registered title. Has its own registered title, has a proprietorship register. And the chargers register. Everything is basically recorded. Every single interest that affects that land, that estate, is recorded. Now the trust of land here is basically, let's say this freehold land over here. It means that the land is held under a trust. It could be an express trust, or it could be either an implied trust. So there's basically the trust. So it's the land is the trust itself, the trust of land. It's held by the trustee, and it's held by also the beneficiaries. Now let's say that let's say that the trustees want to convey the legal estate. They want to convey the legal estate. If they, I mean, I'm saying legal estate for value. For value, it has to be, because according to Section 29, if it's if they do not convey the legal estate for value, it does not qualify as a registered disposition that it can basically postpone the interest of prior interests that are unprotected. I mean, if for example an equitable estate is sold, if there is an equitable estate, let's say an equitable mortgage or an equitable lease, then the trust of the trust basically, which means this guys over here that are the persons that are holding the equitable interest, they're gonna be and they're gonna be taking priority against the that person here. Let's say an equitable lessee, since he has a mere equity, he does not have the legal estate. And since he has a mere equity, when equities compete, since that's an equitable interest as well, I mean the trust is an equitable interest as well. So the interest that this parties over here hold interest is equitable according to section 28 of the Land Registration Act 2002, regardless of whether there's equitable lease or an estate contract, which is an equitable right, equitable proprietary right, again, estate contract, basically a contract of sale, but not actually the conveyance of the legal estate contract. Those are all equitable rights, and they cannot be registered in their own right, so therefore there's no title, there's no basically separate title for those ones. Estate contract, even no matter regardless of the fact that they are not entered on the charges register, simply because this interest that's held here is prior in time, it's going to be binding on those interests. However, when there's a conveyance of the legal estate and consideration has been given, then the conveyance of the legal estate and accordingly it's registered. When it's registered, it's going to be binding on the trusts of land. Now, let's say that well, it needs to be understood that only that the trust of land is not entered on the proprietorship register. It's not entered on the charges register. I'm sorry, and therefore it cannot be protected. It cannot be seen by other people that the equitable lessee or the estate contract of the freehold land. In either case, he can, for example, the freeholder can give an equitable lease to someone, and also equitable estate, and also enter into an agreement with another person to sell the land, so he can receive the profits of the rents that are going to be paid by this person over here. I'm just explaining that so there's no clash between those equitable interests. Let's say the estate contract is prior to the equitable lease. Let's say the estate contract. However, the trust of land is still there, so it's prior to everything else that's recorded. And let's say that he actually has sold the land, and then he proceeds to the trustees, basically. Trustees, they proceed to convey the legal estate here. So they proceed to convey the legal estate, because that's what's outstanding, to the person that holds the estate contract. So he can be conveyed the freehold land, the legal estate, and when the legal estate has been conveyed in his name, he's going to be able to register this. It's going to be able to be registered. This is as the proprietor in the proprietorship register of the title that affects the freehold land. And it's definitely then an estate contract. We've already been through that by explaining the mechanics of an equitable mortgage, when the it's not that preferable, and because an equitable mortgagee sometimes, unless the a deed has been made by deed, the mortgage, and there's a power of attorney, or either a trust deed inserted in the deed, basically a power of a trustee that it allows the It says that the mortgagor is holding the land in trust for the beneficiary, and that the beneficiary is the mortgagee, the equitable mortgagee, and at any given time, basically, well, that's when he defaults on the loan, the mortgagee could be will be enabled to sell, to appoint himself as a beneficiary, a trustee. He can therefore convey the land to himself, the legal estate, and or he can convey the legal estate to the a new purchaser, who will accordingly be conveyed to the legal estate. He can do it either way. Can convey to himself, can convey it in the name of the mortgagor to the purchaser. The land is going to be more attractive since the purchaser is going to be recorded in the registry. If he has an estate contract, mere estate contract, there's a lot of question marks. The land might be sold, the legal estate might be sold in breach of contract to someone else. Fraud might be committed. People wouldn't want to deal with someone who holds an estate contract because of the uncertainty that befalls the fact that there is no separate title for an estate contract, for an equitable mortgage, for an equitable interest, that affects a land, and nothing is recorded in there, especially in the charges register. So people don't know. There's uncertainty whether they're dealing with someone who's holding an equitable estate. So that's why purchasers prefer, and people in the public in general prefer legal rights, especially because of the fact that they take priority. I mean, this estate contract, I mean, you don't really know who's before that, and even I mean, the trust of land will have priority without there needing to be any it's basically going to be an overriding interest over that estate contract. Basically, it's basically an overriding is what I'm saying. Is like it's gonna take priority since it's there prior in time and was created first. However, if the conveyance of the legal estate is like here, conveyance of the legal estate by the trustees is passed, is transferred according to Section 27 of the Land Registration Act 2002, that person who holds the legal estate will be able to claim a better title against the trust of land, unless the trust of land proves to be an overriding interest. And we are going to talk about in due course of this video what an overriding interest really is. So let's say the trustee does that and conveys the legal estate. Now it needs to be understood that regardless of an overriding interest in land, I mean the trust of land, that interest over here by the beneficiaries, whose interests are attached to the property, regardless of the fact that there is a conveyance, if there is no breach of trust, for example, if the trust itself, so let's say here, so the trust is either an implied trust, implied trust, or an express trust. If the trust, it's very important to understand, if the trust itself gives the power to the trustees to authority according to agency principles, because the trustees are basically agents of the beneficiaries in equity. As agents, if they can, there's powers for them to convey the legal estate, mortgage it, or sell it to someone, the freehold land basically, and convey it for value. If that can happen, then it's the trustees have authority and there's no breach of trust, and therefore the even though the trust of land is going to be the beneficiaries here, that interest, that when we refer to trust of land, we're talking about an equitable interest held by the beneficiaries, the people that in the first place have been nominated when there's an express trust, either by the settlor, the person that sets up the trust, the express trust, or if there's an implied trust, when there's a common intention or evidence that they are also entitled to a benefit directly affecting the house or property. That's what needs to be understood. For example, it could be, for example, an implied trust could be a wife and a husband, implied trust, and a husband, and the land might be in the husband's name, so he's basically an equitable trustee. He's basically a trustee, and there's either a resulting trust or a constructive trust. He holds that in favor of his wife, who has in some ways, recognized by the law and equity, contributed to the purchase of the land, and not only that, she needs to have actual occupation in order for her to claim an overriding interest. The thing is, if there's authority for the husband to do that somehow, let's say there's express trust, and I'm gonna talk about the implied trust in due course because it's a little bit slightly more complicated. If there's a power that's like here is like the trust instrument, let's say, and it says you can sell the house. We're talking about the legal estate, so we're gonna put a tick here. So it says you can do it, okay? Then the let's say the trustee, we're not gonna refer to overreaching now. I mean, for now there's like one trustee. If the trustee is basically sells it to someone, this person here, and he conveys it, then even though it's an overriding interest, which means there is this an equitable interest, it's a trust of land, and there is actual occupation at the time of the completion, when the person actually has bought the land before he registers it, because and it is at the time of the completion, because if there's no actual occupation, if the actual occupation arises after that, after completion, it would be unfair for this person here to have committed himself to the trustee, the implied trustee or the express trustee, the legal proprietor actually of the land, who's registered. His name is actually here on behalf of that guy. Yeah, let's not forget that this person here is the beneficiary. So if he conveys this is going to be fine. It's because there is authority and the beneficiary has he has basically committed himself, and he has also had the opportunity to check whether there is an occupation, actual occupation before the sale. If the if that person over here actually lives the land, is not happy, it's not basically living in that land, is not discoverable his interest until after completion. It would be really unfair to him, because he would have already bought something that he cannot he will be bound to pay the price of the sale. He'll be bound with the interest he'll be bound to the interest of this guy over here, and it's gonna be really a nuisance. I mean, this guy over here might he doesn't really want that guy in his land, although he's gonna be bound. However, so that's why the time that the actual occupation can bind this person over here is at the time of the sale, just before completion, not after the completion has been after he has purchased the estate contract and he actually proceeds to register it. So it is a registered disposition according to section 29 of the Land Registration Act 2002. So that's fine. I mean, there is authority and there's no breach of trust. Therefore, even though that actual occupation is binding, the overriding interest that basically, according to Schedule 1 and 3 of the Land Registration Act 2002, there is basically the is equitable interest plus actual occupation, because there's authority, actual occupation, because there is authority, there's a power, it's just fine, it's okay, and this person here has waived, I mean, it really has waived, but there's authority, and the mortgage can be done, or the sale can be effected, and regardless of the fact that it's binding on the trust of land. Now, this is if there is authority, therefore there cannot be, I mean, there's authority to do something by the trust instrument. Definitely there cannot be breach of trust. How can you breach something that you authorized to do? You can't. Breach, no. Breach of trust. Accordingly, the money that the trustee will take will be, let's say, here's the money. Sorry, here's the oh, there's some problem here. Hold on. Is it trust? Is the here the money that he will take? No, the trustee will take money here by selling that, and it's going to be held, it's going to be held in trust, the money here, pounds, by that guy to the trustee, the legal proprietor, of course, in trust for that person over here, right? That person will, because he has given authority, and he says, okay, listen, you can do that, the mortgage can be done, it can be effected, or the sale can be effected, I'll need the money. Now, if there is no such power in the trust, the rights of the beneficiary are directly attached to the land. So there's going to be a problem when the trustee sells the land, because, or the implied trustee over here sells the land, if there is has not been any common intention or any evidence pointing to the fact that the wife, that's the beneficiary, again, in the presence of the beneficiary, wanted the husband, who for many purposes, various purposes, just took the became the registered proprietor of the land. It's gonna be difficult. If there's no breach of trust, if there's a breach of trust, I'm sorry, then that means that this sale is wrong, cannot happen. And when there is a breach of trust, if the right of that person, if he can prove that at the time of the sale he was an actual occupation, then this estate contract, this sale, legal conveyance, will have no effect, and this is this overriding interest. You can prove that he had it was a trust. It's already said for the purposes of this video, and he can prove the actual occupation at the time of the sale, not after the sale, before the sale and after the sale. Before the sale, at the time of the sale, he can come forward and say, yeah, I have an overriding interest according to Schedule 3 of the Land Registration Act. The Land Registration Act 2002, Schedule 1, Schedule 3. Schedule 3 here, we're doing with Schedule 3 because it deals with a registered disposition. Schedule 1 deals with the first registration. We don't have first registration. Here we actually have a registered disposition because the land is already registered, or it could have been unregistered land. And if it was the first mortgage or the first transfer of the legal estate, then according to Section 4 of the Land Registration Act 2002, it would have been triggered to compulsorily register the title, and at the same time it would have occurred a disposition. So Schedule 3 would have applied, and this person, if he could prove that there was an actual occupation, and that was this proprietary right that it had behind the trust of land, which is no doubt in anyone's mind that trusts of land are recognized to be equitable proprietary rights, then he will override this interest is going to be overriding, which means it's going to bind this person over here when he registered his interest. So it can take a legal effect. It's going to be an overriding interest, because it's not on the charges register. Trust of land cannot be recorded on the charges register. Sorry. However, if it will override the interest of this person over here, even though it's a registered disposition. If it was an unprotected registrable interest, basically registrable, that means that it can't be registered against the title, and it wasn't registered against the title, it would be postponed. Its priority would have been postponed because there was a conveyance of the legal estate for value consideration. Value must be not nominal, must be not under value, and no gift. It must be a value, must be consideration involved. But that's for registrable estate, because that interest here is not recorded on the charges register. If this is proved, equitable interest and actual occupation at the time of sale, then it will override. Doesn't matter whether it's recorded or not. It's an overriding interest. The other interest has to be recorded in order to be protected, to take priority over registered disposition. If it was another interest, let's say another estate contract here, this estate contract would have taken priority again, regardless of the fact that it was registered or not, because the later estate contract was an equity, and when equities prevail, the first in time always comes first, according to Section 28 of the Land Registration Act 2002. Thanks very much. In the second part of this video, we're going to talk about what happens when the breach is authorized and how it can be authorized. And in a due course, we're also going to talk about overreaching. For now, I think this is enough for the viewers and the persons that are taking a keen interest in this area, in this particular field of land law and land registration, and with a particular view to trusts of land, which can be an overriding interest under certain circumstances. I hope that has been helpful to you. My name is Dimitris Koulafetis, and I will see you all in the second part of this video. Thank you very much.